Subpart D, Part 107, Enforcement. 107.301, Delegated Enforcement, and delegation for the Administrator of the Pipeline Hazard Material Safety Administrator, the Administrator of the Hazard Material Safety Office of the Chief of the Council, exercise authority enforcement of federal hazardous materials transportation law subchapter and subchapter C with the subchapter in accordance with the 105.3 and for the child of the 107.303 for the purpose of the scope of the subchapter to cover the various enforcement authorized for the construction of the Associated Administrator of the Hazard Material Safety Office of the Chief of the Council associated with the section prescribe the procedures governing exercise of those authorities of the imposition of those sanctions. 103.305 the investigation in accordance with the delegated authority under Part 1 of the Associated Administrator may initiate the investigation related to complying with any of the provision of the subchapter C of the chapter with any special permit approval of the order issued thereunder in court relating to the Associated Administrator and curve of the voluntary production of the documents for the subject with the 105.45 of the hearings may be the deposition of the pursuant to the 149 U.S. Code 5121A. Associated Administrator may with the investigative conference for the hearing, the course of any of the investigation inspections investigated on Title 49 U.S. Code 5121A with the conduct of the personal duly authorized for the purpose of Associated Administrator inspection. 49 U.S. Code 5121C with the conduct of the hazard material enforcement special of the hazard material complying with the investigation, also known as hazmat investigators, or whom the Associated Administrator of the designated for the purpose of the investigator will, on request of the exam of the credential examination for the credentials may be the retrieve of the investigator may be the administrator for the oath of receiver the affirmation for the matter of the investigation of the Associated Administrator. An investigator may gather information responsible may include but not limited to interview statements of the photocopying, the photography, video, and audio recording. With the current director of the field operation pipeline hazard materials safety administrator of the investigator may be submitting with the production of the documentation tangible evidence based the information available to the investigator and documents evidence material for the advance for the determination aligned with the subchapter and subchapter C with the service with the opinion show the accordance with the 105.50 with the person with the subpoena the director may review the subchapters applying the office of the council accordance with 105.55A with the subpoena issue from the paragraph may be enforced with the accordance with 105.55 the notification of the person with the subject of the associated administrative investigation with the request of finishing the information documentary evidence, notify the general purpose of the information, the evidence, of the determination of the fact of the scope of the investigation, indicate the further action of the necessary and warranted at the time personally being investigated, notify the investigation of the close without prejudice to the further investigation of the Associated Administrator. The confidential information received the investigation under the section will include the identity of the person investigated and any other person who provided the information during the investigation shall remember the confidential the investigation file the exemption other appropriate exemption and public disclosure requirements of Title 5 U.S. Code 55.2. Compliance and order civil penalties 107.307 and 107.307 when associated administrator for the office of the chief of the council with a reasonable belief that the person was knowingly engaged in the conduct of the violation of federal hazardous material transportation law and provision subchapter of this subchapter and subchapter C of this chapter exemption of the special permit if they order issued thereunder for the associated administrator or office of the chief of the council actually for the enforcement authority may if the issue the warning letter provided 107.309. If they perceive the civil penalties provided either 107.310, 311, issue with the ordering of the direct complaint with regardless of the warning letter may be issued the civil penalties seeking any other remedy of the under the federal hazardous materials transportation law. In the case of the proceeding of an issue of the failure to comply with the exemption of the special permit, the allegation of the violation, the term of the condition thereof, the concern of the associated administrator of the office of the council. Of the allegation, special permit hold the party with the special permit fail with the failure to comply with the underlying regulations which relieve the granted special permit. 107.309 warning letter. Associated Administrator of the issue the warning letter to any Associated Administrator believe the committee with the problem of the violation of federal hazardous materials transportation law and provision of the subchapter C with the any possession permit issued there under warning letter is issued in section include the same of the fact with which the Associated Administrator determined that the person with the committee with the problem violation, same with the reoccurrence of the problem violation cited may be the subject of the person enforcement action the opportunity to respond with a warning letter by submitting her information explanation of the concern with the problem violation cited therein. 107.310 ticketing and eligible violation did not have the directive of the substantial impact with safety. Associated Administrator may issue the ticket. The Associated Administrator issue the ticket mailing is certified registered mail to the person eligible to have the commitment of the violation of the ticket, including the statement of the fact with which the Associated Administrator made with the conclusion that the person have committed with the alleged violation. The maximum penalty provided by the statute provided the full penalty determined the PHMSA civil penalty guidelines statutory criteria for the penalty. Assessment of the ticket penalty amount, the statement within 45 days of the pay, receipt of the ticket, the person with the penalty in accordance with the paragraph D with the section make an informal response to the 107.317 the formal administrative hearing 107.319. If the person makes the informal response to the question, the formal administrative the hearing with the associated administrator forward with the inspection report of the ticket, the response to the office of the chief of the council the processing under 107.307 107.339, except for the office of the chief of the council will not issue the notice of the probable violation of the 107.311. The office of the chief of the council may impose propose the civil penalty does not exceed the full penalty set forth in the ticket. The payment of the ticket penalty, the amount of the must be made within the course of the instruction of the ticket. If within 45 days of receiving the ticket, the person does not pay the ticket amount, make it informal to respond to the request. The formal administrator of the hearing person will waive the right to make the informal response. With the hearing to be made with the violation over the ticket, the penalty amount. PSMSA 107.311. The notice for the probable violation. The office of the council may serve the notice of probable violation person alleging the violation of the one or more provision of the federal hazardous materials transportation law of the provision subchapter the subchapter received the chapter of the aim of the special permit order issued therein under and note the probable violation issue under this section included information. A situation provision of the federal hazardous materials transportation law of the order is issued under the subchapter C and of this part of this chapter determine that any special permit issued there under the office of the council believe that the respondent to the violation violated. A statement of factual allegation with the domain of the remedy of the action of the civil penalty. Both the statement of the respondent of the rights of personal and written of the oral examination information augmentative the answer to the allegations, mitigation of the sanctions of the notice of the probable violation. Statement of the respondent of the right to the request in the hearing of the procedure of the request. The hearing the indication for the case of notifying the probable violation proposed in compliance order with the statement the proposed action be taken with the respondent achieve the compliance. In addition, with the case of the notice of the probable violation proposed in the civil penalty, the statement of the minimum civil penalty which the respondent may be liable, the amount of the preliminary civil penalty be settled by the office of the chief of the council constitute the maximum amount of the chief of the council may be seek through the proceeding the description manner of which the respondent makes payment any money of the United States. As the result of the proceeding, the office of the chief of the council may amend the notice of the probable violation any time before the issuing of the compliance with the order of the assessing a civil penalty in the office of the chief of the council alleged for the new material fact for the seek of the new additional remedial action of the decree for the amount of the proposed civil penalty issued with the new notice of the probable violation under this section. 107.313 reply. Within 30 days of the receipt of the notice for the probable violation, respondent must be either admit the violation of the 107.315 make the informal response. 107.317 requires the hearing with the 107.319 and failure to respond with the file that is provided with the section constitute the waiver of the respondent is the right to appear with the concept of the allegation authorized the chief of the council without further notice to respond to the time of the fact that the alleged in the note of the probable violation issue the order of the direct compliance of the SS for the civil or proposed the notice of failure of the request of the hearing under paragraph A3 of the section constitute the waiver of the respondent right to the hearing. Upon the request of the respondent, the office of the chief of the council may with good cause shown with the file within 30 days to prescribe the note of the probable violation down to 30 days responsible period. Or 107.315 the admission of the violation respond with the notice of the probable violation issued within 107.311 and respond made admit the alleged violation group, they accept the term of the proposed compliance order to the private pay the amount of the preliminary assessed civil penalty or proposed with notice or both. If the respondent agrees with the term of the proceed with the complaint with the chief of the council issue with the final will the prescribed the remedial action to take with the respondent payment of the civil penalty with the amount of the civil penalty exceeds $10,000 may be must the wire transfer of the Federal Reserve communications the system of the video account of the U.S. Treasury detailed instruction make with the payment of the wire transfer may be obtained by the final financial operations division AMZ 120 Federal Aviation Administration Mike Maroney Aeronautical Center, the P.O. Box 25082, the Oklahoma City, Oklahoma 73125. Payment of civil penalty the amount of the penalty of $10,000 less must be made either by the wire transfer set forth in paragraph C of the section certified check with the pending order payable to the U.S. Department of Transportation, submitted to the final answer financial operations division AMZ 120 Federal Aviation Administration Mike Maroney Aeronautical Center, P.O. Box 25082, Oklahoma City 73125. All right, 107.317 informal response. Respondent notice of the probable violation under 107.311. The respondent must submit the official with the issue with the notice written explanation information augments for the respondent of the allegation the term of the proposed compliance order of the amount of the preliminary civil penalty. The respondent may include the informal request respond with the request of conformity upon the request of the respondent from a conference or that may either be in person or telephone or request of the conference must be set forth the issue the respondent will raise at the conference. Upon receipt of the request of the conference is under paragraph B of the section of the Chief Counsel and the Consolation of the Associated Administrator arrange for a conference. As soon as practicable with the time and the place of the mutual convenience, the respondent written the explanation, information, or arguments for the respondent present the conference to consider the Chief of the Council reviewing the notice of the probable violation. Based on the review of the proceeding, the Chief of the Council may submit for the notice of the probable violation whole in the part does not dismiss the whole as he issued the other directing compliant with the assessing of the civil penalty or proposed notice both. 107.319 requesting a hearing responding with the notice of probable violation. 107.311 responding may request the formal administrator of the hearing with the record before the administrative law judge that contained by the office of the Chief of the Council request for the hearing under the paragraph A of the section must state with the name of the draft of the respondent of the person submitted with the request for the name of the respondent to state with the allegation violation that is omitted. State generally of the issue of the rate of the respondent of the hearing of the issue, not rate of the request not barred in the presentation of the hearing to be a draft official of the lease, who is issued the notice after the request of the hearing, comply with the requirement of the paragraph B of the section chief obtained by the American Minister of the Law Judge residing over the hearing will notify the respondent of the request of the administrative law judge. Further, matter of the proceedings general are conducted by the administrative law judge, except for the chief of the council. Respondent may come up with myself with the case of 107 to 327 and subpart with the order administrative law judge voluntary dismiss the case under 104 rule 4181. The federal rule of civil procedure without the order of the administrative law judge in the event should the compromise the settlement of the dismissal of the chief counsel expedite notified the American law the administrative law judge thereof at any time that the request of the formal administrative of the hearing of the prior with the decision issue of the decision final order administrative law judge respond with withdrawal such request of through the terminating of the jurisdiction of administrative law judge in the case of such withdrawal constitute the revocable waiver respondent's right to such a hearing. The fact of the allegation proceeding and proposed sanction will represent of the probable violation to which the request of the hearing relates. 107.321 hearing. To the extent practical the hearing is held with the general vicinity of the place of the alleged violation occurred with the place convenient with the respondent with the testimony of the witness shall give it under the oath of the hearings that should be recorded verbatim. Hearings are conducted according to the federal rule of the evidence, federal rule of the civil procedure for the House of the administrative law judge may modify the determined necessary for the interest of the full development of the fact in addition of the administrative law judge, administrative oath, the affirmations and issue the subpoena and provide the 105.54 for the adoption principle for adoption procedure for the submission of the motion, the evidence, the other documents pertaining in the proceeding. Take care, cause of the description of the to be taken the rules offered of the proof of the receipt of the relevant evidence, examine the witness of the hearing, convey the recess, reconveying the adjourning, and otherwise relegate the course of the hearing, hold the conference of the settlement, simplification of the issue, and other proper purpose. And take any other action authorized and consistent with the provisions of the permitted law that may be expedited with the hearing aid with the disposition issued raised therein. The official who is issued the note of the probable violation his presentation with the burden of the proof of the facts alleged for the respondent may appear with the heard of on the behalf of the counsel of the chief of the respondent, the chief of the counsel, the other offer relevant information, including the testimony which believe the conservative opposition to the allegation in which may bear with the sanction of the conducting cross-examination may require the full disclosure of the facts. The administrative law judge decision after this consideration make matters for the record of the administrative law judge shall issue the dismissing notice probable violation who will in part with the granting of the sanction of the official chief of the council notifies the administrative law judge does not dismiss the notice of the probable violation in whole uses the order directing compliance with the assessing of the civil penalty if the proposed notice both the order and includes statement of the finding of the conclusion and the reasons for their all material issue and the fact of law of discretion within 20 days of the receipt of the order issued under paragraph A of this section, the respondent does not submit the reading of the acceptance for the term of the order of directing compliance with the appropriate pay of civil penalty in the file with appeal with the 173.25 the case of referred to the Attorney General with the request of the action be brought with the appropriate United States District Court enforcement law terms of the compliance or order or collective civil penalty. 107.325 appeal of the hearing proceeding. A part of the aggravated administrative law judge decision or the issue of 107.323 may file a written appeal with the court for the paragraph C with the section of the administrative office of the administrative of the pipeline administrative of the safety administration east of the safety and Beast building 1200 New Jersey Avenue Southeast Washington DC 205900001. No hearing proceeded as respondent aggrieved by the order and issue with the 107.370 may file a written appeal with the court for the paragraph C with the section administrative of the office of administrative pipeline has material safety administration east building 1200 New Jersey Avenue Washington DC 205900001 appeal the order issue of the subpart of the file with the only be the order of the party save the practically fine within the order of the appealing the party changes challenges including all information or arguments for the permit and pertinent to if the administrator of the PHMSA affirms the order of the whole and part of the respondent must comply with the term of the decision the 20 days of the respondent receipt thereof when the time prescribed in the order of the respondent does not comply with the term of the decision of the 20 days of the receipt within the time prescribed the order that indicates that may be referred to the Attorney General in action for the enforcement action terms of the decision. The following appeal of the state of the effectiveness order issued in 107.317, 107.323, however, the administrator of the PHMSA determined the issue its public interest in has may keep an order directing compliance with the pending appeal. 107.327 the compromise settlement. Anytime there before the order of the issue of 107.317, 107.323, the referred Attorney General of the reinforcement responded with the office of the Chief of the Council with the promise of the follows. If the civil penalty gave the respondent, the chief of the council may offer to compromise the amount of the penalty by submitting an offer with a specific amount of the other party, then offered with the compromise the respondent shall be submitted to the chief of the council who may, after consultation, associated administrator accept the reject the compromised offer save the running of any of the response period of the same. The compromise with agreed with the part of the respondent notified of the writing of the upon the receipt of the pay with the chief of the council. The respondent notified of the writing acceptance of the payment, the full satisfaction, civil penalty proposed assessed of the chief of the council code for the prejudice of the respondent. If the compromise cannot be agreed with the respondent notified of the written and give them the 10 day with the amount of the time of the remain with the outstanding response period with whenever whichever is along with the whatever their action would have the chief of the office, the chief of the council, minister of the PHMSA. In compliance with the orders, cases if the respondent may propose the consent of the agreement of the chief of the chief of council could accept the agreement and the issue of the order in accordance with the term of the chief of council reject the agreement and he directed the proceeding continue with the agreement of the submit with the chief of council must be include the statement of the allegation of the facts respondent channel the reason of the term of the compliance with the order proposed the compliance order that would be burdensome of the respondent which when the terms are not supported with the record with the proposed compliance with suitable the issuance of by the chief of the council admission of all the jurisdictional facts express the waiver the further procedural set, except an albright with the seek of the judicial review, otherwise challenging the consistent validated order, notwithstanding paragraph A1 of the section respondent office, the chief of the council may propose the settlement of the case. The chief of the council agreed with the settlement the respondent notified, and the case is closed with the prejudged and to the respondent. Alright, 107-329, maximum penalties. Person known that violates requirement of the Federal Hazardous Materials Transportation Law order within thereafter with the subchapter of the subchapter C with the chapter of special permit with the proof of the issue of the subchapter applicable to the transportation hazardous material law code for them to be transported, shipped, and liable to civil penalty no more than $78,366 each violation, except for the minimum maximum civil penalty of $1,882,877 for violation result of death and serious injuries, fear, injury to any person, substantial destruction of property with no minimum of civil penalty except for the minimum civil penalty of $451 violation relating to the training. The violation or is continuing one each of the day violation continues a separate offense. A person who knowingly violates the requirement of the Federal Hazardous Material Transportation Law order the issue thereon of the subchapter C with the chapter of the special permit the approval of the issued under the subchapter applicable to design, manufacture, fabrication, inspection, marking, the maintenance, the reconditioning, repairing, testing of the package of the container of the package of the component which is represented, the marked and certified, sold by the person qualified for those of the transportation hazardous material and commerce for the liable to civil penalty not more than $78,376 for each of the violation. Maximum civil penalty $182,877 with the violation result of death and serious injury of the severe injury to any personal substantial destruction of property. There's no minimum civil penalty except for the minimum civil penalty of the $451 for the violation for the relating to training. 17331 suspect consideration. Finally, knowing the violation of the subpart of the office, chief of the council accept the civil penalty, take the following action and count the nature of the circumstances of the violation, extent of the gravity of the violation, the degree of the respondent, the culpability of the respondent, the prior violation, the respondent, the ability to pay, the effect of the respondent, the ability to continue the business, such other matters of justice may require criminal penalties. Alright, 107-333, criminal penalties. Generally, a person knowingly violates 171.2.1, this title that willfully, recklessly violates the requirement of the Federal Hazardous Materials Transportation Law, the regulation, order, special permit, approval of the issue thereunder, which shall be defined under the Title 18 U.S. Code in prison for not more than 5 years, both except the maximum amount of the imprisonment shall be 10 years for any case with which the violation involves the result, release of hazardous material which results in death or bodily injury to any person. 107-335, referral for prosecution. An associate administrator becomes aware of the possible willful violation of Hazardous Material Transportation Law, subchapter C of the chapter A of the special permit order issued thereunder, for which the associate administrator accepted the enforcement of the respondent shall report to the office of the chief of the council, pipeline, hazardous material safety administration, U.S. Department of Transportation, Washington D.C. 205900001. Appropriate the chief of the council refer the report with the Department of Justice for criminal prosecution of the offender. All right, 107-330. The limitation on fine and the penalties. The state of the political subdivision in the Indian tribe to set the final penalty to determine the secretary of the appropriate violation consider the subject listed in 107-202A. No additional fine or penalty may be set for such violation in any other authority. Alright, injunctive action. 107-337. The injunction in general. Whenever the appear of the office of the chief of the council has personal and gave the bounty and gave the any of the or practice for the Constitution, continuing the violation of any provision of Federal Hazardous Material Safety Transportation Law, subchapter C, the chapter of special permanent order issued there under the office chief of the council to exercise the enforcement responsibility of the administration. PHMSA, the delegate may request the attorney of the general to bring action for the appropriate within the United States district court for the such relief the necessary appropriate, including the mandatory prohibition and injunction for the relief in the term equatable to relief, putting unit of damage and providing Title 49 U.S. Code 5122A. Alright, 107-3038, prohibition has material operation provided by the subpart E of the part 109 after the person who failed to comply pay with the civil penalty according with agree with the upon installment of the full of the prescribed timeline with the prohibited conducting hazardous material operations should be immediately cease the all hazardous material operations. All right. 107-339 imminent habit whenever they appear with the office of the chief of the council. Therefore, the substantial likelihood that death and severe injury, severe personal injury will result of the transportation of the particular hazardous material container before compliance order proceeding other administrative hearing of the formal proceeding to abate with the risk of the harm to be complete with administrative PHMSA or his delegate may bring in action the Title 49 U.S. Standard Code 122D be appropriate to the United States District Court for the other suspending restriction, transportation of the hazardous material of these containers or each other equatable relief of the necessary appropriate malatorated of the hazard. And then Appendix A to Subpart D of the Part 107 Guidelines of Civil Penalties.